That was a very nice movie, Blindfold, from the Ukraine. And speaking of blindfold, the world over, justice is depicted as a lady with a blindfold and holding two scales. I believe these are the scales of justice. And having the blindfold is just to indicate that the judgment comes from whatever is being weighed as evidence. They say justice is blind. Speaking of justice, our next panel is very, very interesting. Because you know that saying of, I'll see you in court? No. These panelists prefer not to see you in court. In fact, they prefer to mediate and arbitrate outside of court. So our next panel is the growing importance of sports arbitration in Africa. And we have Ms. NJERI Onyango. She's an advocate of the High Court of Kenya. She's a member of the Chartered Institute for Arbitrators, MCIARB, and mediator and member of the Sports Disputes Tribunal. You heard that? Sports Disputes Tribunal. They prefer to settle out of court. She has served with the National Olympics Committee of Kenya and Kenya National Sports Council. She is a member of the FIVB Legal Tribunal since 1996 and UK Sports Resolution and Vice Chair, Kenya Premier League Independent Complaints and Disciplinary Committee. Welcome. We also have Dr. Donald Rukhari from Uganda. He's an advocate of the High Court of Uganda, Vice President of CANA and Secretary General of the Uganda Olympic Committee, an arbitrator of the International Court of Arbitration for Sport, CAS. He was recently appointed MEMOS professor and teaches governance on the IOC MEMOS Master's Program. Then from Switzerland, we're joined by Jean-Philippe DUBEY. I hope I said it right. He's the head of the CAS Scientific Department Court of Arbitration for Sport, CAS. He leads a team that focuses mainly on the overview of the CAS case law on scientific assistance to the arbitrators and the other counsels. And as our mediator, we have a very nice gentleman who I've never met, by the way. We just communicate regularly on email and WhatsApp, technology, virtual, KISS 2020. His name is Mr. DEV KUMAR from the United Kingdom. He's an internationally experienced sports lawyer and academic with experience as a football intermediary, arbitration, mediation. The growing importance of sports arbitration in Africa. Dev, over to you.
Right there, can you hear me clearly? Can everyone hear me?
Yes, I can.
Excellent. Thank you very much, Chris, for the kind introduction, and it's a pleasure to be here, of course, at the Kenya International Sports Film Festival 2020. It's an honor to be the moderator of this panel and to have a conversation with good friends of mine within the industry. If I may humbly do so, Chris, I know you've done a great job in terms of introducing all of the individuals concerned. However, I feel that all of them deserve a little bit more ceremony. So NJERI Onyango has got wonderful experience, a glittering career in legal practice of over 30 years, having also consulted on the Sports Act in Kenya. But we must not take away from the fact that she was also an athlete, having partaken with great expertise in volleyball, taekwondo, and tennis. Our good friend Dr. Donald Rukhari, also a former athlete, being a international level swimmer for Uganda, now sitting as the chairperson for the National Council of Sports and the president of Uganda Swimming, as well as being an EXCO member for the Uganda National Olympic Committee and the chair of the Legal Commission, if I'm not mistaken, Dr. RUKARE. And Jean-Philippe DUBEY. Mr. DUBEY, it's a pleasure to have you here. Someone that I would call the man that makes it happen, one might say. Someone who sits in the background at the highest sporting authority in the world and has done so for 15 years, and assists and enables the progression of cases by advising both CAS counsel and arbitrators alike. So thank you all very much for your participation today. And Jean-Philippe, if I may humbly do so, I'm going to invite you to begin very shortly. I'll give a very potted history of how sports arbitration has developed with the CAS, and you'll correct me if I'm wrong anywhere. 1981, if I'm not mistaken, Juan Antonio Samaranch ideated the principle of having a tribunal for sports, and soon enough, Keba Mbai was charged with leading a task force in setting up the first set of statutes. I think it was the 30th of June 1984 when the IOC formally ratified the statutes and CAS came into being. Now, without delving too deeply into how this has evolved over the past 30 years with a couple of reforms in tow, sports arbitration has become increasingly popular and effective for dispute resolution worldwide. The CAS is housed in Lausanne in Switzerland. However, it's also got a number of regional hearing centres around the globe, satellites of sorts. So there have been recent calls for there to be a regional hearing centre in Africa, something Dr. RUKARE and myself have both had some exposure and involvement in. And with that, Jean-Philippe, I'm sure the audience would be grateful for your words on what a CAS regional hearing centre might look like in Africa, as well as how something like that would actually work.
What I can say about this is, what could happen in theory, and what is more realistic in practice. In theory, there is nothing that prevents any entity like an arbitration center, for example, to set up arbitration rules that in the field of sports and try to convince individual athletes or clubs or federations to use their services by putting an arbitration clause in favor of this organization in the contracts or in the statutes. This can be done for covering disputes at international level. This is what CAS has done. At continental level or at regional level even. So it's only a matter of deciding what is the objective to be targeted. But what is more realistic, as you mentioned, is probably because, well, maybe let's say it this way. This would not be very realistic because setting up an arbitration institution is not easy and it's quite expensive, and the question of funding is a key question. So mainly in order to keep the independence of the institution, for example. So even at international level, big institutions like FIFA, for example, had first the idea of setting up their own arbitration tribunal, but then decided to join CAS instead. And most of the sports organizations nowadays have a clause that is in favor of CAS. So as you mentioned, what is more realistic is probably, of course, I'm not a member of the ICAS, and this is more of a matter of ICAS policy, but I can say what has been done elsewhere. It would be very interesting and benefiting for Kenya and the region to have an alternative hearing center under the auspices of CAS. So just to make sure that I am understood correctly, this is not an alternative CAS. but it is a place, a venue, a hearing center that is set up in order to facilitate the organization of CAS hearings in the region. For example, if all the parties to a case are from the African continent or from the region, and this would be definitely beneficial for the region, because it would help developing awareness of arbitration in the region, and it also could help in having more lawyers involved by being either on one side appointed on the list of CAS arbitrators at the CAS, or simply by working as representatives of the parties that are coming from this region as well. The ICAS is aware of the interest for sports arbitration in Kenya and in the region. And this is also what our Director General, Mathieu Reb, said last year in a seminar
in Nairobi
at the Chartered Institute in Nairobi. Yes, exactly. And so the question of Kenya becoming an alternative hearing center is certainly on the desk of the ICAS. But of course, for the time being, for obvious reasons due to the pandemic, the ICAS has not been meeting very much often. And so the question will surely rise again next year or whenever better times come.
And Jean-Philippe, if I may do so, because I'm quite conscious that many of our audience members may not be au fait with CAS or may not be legal practitioners, would you very kindly just expand upon what ICAS is and why we're talking about its relevance in this particular instance?
Okay. The Court of Arbitration for Sport, so what we name CAS, is organized under the auspices of a Swiss foundation that is named the International Council of Arbitration for Sport, so which is the ICAS. So those are the people that are leading CAS, as I would say, because it is our or it is the people that are in charge of the running of the Court of Arbitration for Sport.
And in relation to the regional hearing centre, and thank you for that clarification, by the way, Jean-Philippe. In relation to a regional hearing centre, you and I were discussing very briefly the other day an anecdotal matter where I was instructed in a case at CAS at a regional hearing centre, where there appeared to be a bit of a misunderstanding with regards to what rules would actually be used, whether there would be a usage and a reliance on local rules or local practices, or whether there should be a reliance on the rules which dictate play at CAS Lausanne. Would you be able to kindly emphasize for the audience exactly how a CAS regional hearing centre would work in that sense?
In fact, a hearing center is only a venue where hearings would be organized. But this means that, of course, CAS rules apply, and it's the CAS Code of Sports Arbitration that would apply to a hearing that would be organized at this place. Excellent.
Now, thank you very much for that, Jean-Philippe. And I think it's interesting to discuss this because, and Dr. RUKARE, if I may, I'll refer to your good self. You and I have been involved or directly in certain parts, in discussions that have led to calls for there being a regional hearing centre in Africa from CAS. But sometimes it may be the understanding is not fully there with regards to what a hearing entails. So thank you very much for that, Jean-Philippe. Now, if we move away from the CAS itself for a moment, and we do speak about sports disputes and sports arbitration, there's also a lot of good work going on in Africa at the moment. And Donald, your good self are no doubt a key proponent, either directly or through your great influence, in the positivity around that is being used in Uganda at present. What range of sports dispute resolution mechanisms do we have in Uganda? And if I could ask, is it always accessible to the end user, both in financial terms and their understanding of what they've got availability to use?
Well, thank you, Dave, and good morning to you. It's a pleasure to be on this panel from Pierre and also with NJERI. And Dave, you raise a very interesting question. I think the way I would quickly dive into this is to say, one, we are seeing a growth of the acknowledgement that sports law is indeed a branch of law, not only in Uganda, but across Africa. Because a couple of years ago, I think there was a bit issue as to whether, when I was in law school, as whether sport exists and whether it's actually shown a practice of sport. I think it's becoming evident that sports law is a big embraced by the legal profession in Uganda. We can see this one way is it's being taught in some of the universities here, which wasn't the case a couple of years ago. And then if you now transition into what are the various forums we have for sports law, the most typical default drive would be the courts of law, the ordinary courts of law. That's where a number of cases would go, typically around elections, issues around maybe misappropriation of funds, but it's mainly around governance questions.
Sure.
So that's the kind of main kind of forum that has been the default drive. And normally by lawyers who do not necessarily have a kind of the greatest bandwidth when it comes to an appreciation of the various tenets of sports law. But as I said, this is changing, and I see that the general travel direction seems to be moving towards increasingly realize that sports law is indeed an area of focus. The other areas which typically a lot of the sports dispute resolutions are resolved in most of our countries is within the clubs, within the federations, within the national associations. There's, again, it's not one size fits all. Some do have very elaborate judicial panels. For example, the Football Association, the Federation of Football Associations of Uganda, known as FUFA, have a dispute resolution committee. I think they borrow this from FIFA. They have an appeals committee and all these things. So they have a very elaborate judicial body with a number of lawyers in it, and you can actually go there and have your disputes, whether it's an issue of payment, an issue of transfer. That is also done. So there are some federations that have very elaborate internal mechanisms drawing from the international federations like FIFA. Others have disciplinary panels, again with varying degrees of practice. Some have lawyers, some don't have lawyers. Not all of them have arbitration clauses that Jean-Pierre was talking about in terms of having a well-elaborated arbitration clause in your statutes or your constitutions.
Sure.
And then others also, with all due respect, and Jerry might know this, they'll resort to the court of public opinion. And the court of public opinion is not really necessarily a kind of a legal process, but they'll also go to the press and they'll go to other politicians and those also are another avenue, let's say the non-judicial side of things. But just to wrap it up, Dave, we have some internal mechanisms. So disciplinary panels set up within constitutions, within statutes. Some are very elaborate, like the football. Others will go to court. But also others have also used the CAS mechanism by having reference. I've seen a number of cases, one or two, coming from Uganda, into the caste system as well. So that's what we have, Dave, at the moment.
Excellent. No, thank you very much for that, Donald. And again, I refer to Uganda specifically because it's generally been regarded in very glowing terms with regards to sports administration and development. And as I highlight, you, Dr. RUKARE, are Mr. Governance, so no doubt you're a key influence in that positivity. We've got NJERI ONYANGO with us today, and I'm quite conscious of where you are, Ms. Onyango, at the moment, and the challenges we may have with the connectivity. So I want to get you involved as soon as possible before we lose the benefit of your knowledge. NJERI, you have, as we said right at the start, you've had a glittering legal career, and you've had so much involvement in sports administration and sports law in Kenya. In addition to that, you've been synonymous, one might say, with the Sports Dispute Tribunal in Kenya, which was, at the time it was set up, I believe in 2013, if I'm not mistaken. It was one of only a handful of sports dispute tribunals around the world. So whilst we are here talking about having a CAS regional hearing centre and some of the positivity that we can glean from that, Kenya has been following its own pathway for sports disputes for a short while. And I'm sure the audience will be grateful to hear some of your experiences in relation to the Sports Dispute Tribunal in Kenya, as well as some of the positive and negative examples that other countries in Africa might be able to take therefrom.
Good afternoon, everybody. Sorry for joining in late. As you've said, I have had challenges in my connectivity. Well, the Sports Disputes Tribunal, you correctly say, was set up through the 2013 Sports Act Kenya. And I think the first sitting we had was sometime in April of 2014 after the selection. Clearly, the positive part about the tribunal and its constitution is the anchoring of its powers and selection process in a statute. That begins to give it credence, it begins to give it independence, it also begins to give it the confidence of the users because of the manner of selection of the persons to sit in the sports or to be members of the sports tribunal itself. That, of course, and the anchorage at law, and considering that the persons to be selected to sit in the tribunal is by law required to go through the Judicial Service Commission, and the specifications are given for the qualifications of such persons, then you start to see the positive side about it and the confidence that it builds. And I must also say that the Judicial Service Commission did a good job at filling those positions because of the diversity of knowledge and abilities that they brought in through the members. Now, we have had we came from a situation where most of the federations were run by one-man briefcase carriers, and the sports law, the Sports Act 2013, of course, now started giving specific definitions about even the electoral process in the federations, therefore giving an anchorage on the governance aspect and the qualifications and demeanor of the persons that are elected into the positions in the federations. And then now, if you cascade that, and of course the financial management aspect, if you cascade that now towards disputes that may arise in the sporting field, and considering the jurisdiction and powers that have been granted to the tribunal, then you start seeing the beauty about sports resolution, and more so the fact that the tribunal has been given powers to proceed both in the substantive procedural manner that we know of courts and dispute resolution, but the tribunal was also given powers to deal with issues or matters that are brought before it through the alternative dispute resolution, which also we find anchored in our constitution. I believe that under the provisions for judiciary, the tribunals are recognized, and they have been given, both the normal courts and the tribunals have been given power to use ADR as an alternative means of resolving disputes. That has given us a lot of leeway. It's given us a lot of what do I say, room to try and resolve disputes, so that in certain matters we've even resolved disputes in the formal process, and then taken the parties out and started doing the other things with them that have led to the dispute that came before us. For instance, we've had players coming, athletes coming and saying, we are not happy with the selection. And that will mostly happen when you have major championships, this common or All Africa Games. So once the players come before you, then you realize that federations have do not even have athlete selection mechanisms or rules, and we sit back with them now, even after decision making, to try and put athletes or even technical bench selection criteria. And that is, of course, now giving athletes and even the technical benches more comfort, and they know that if something happens, then they have the tribunal to come to. The other thing that we have done is, of course, to go into the issues of trying to give governance grounding in the various sporting federations arising from the disputes that have come before us. And of course, that we have encouraged the building up of internal dispute resolution mechanisms. Many of the federations had rules, but not the systems. You just find somebody has said, "Oh, any dispute shall be resolved through blah blah," but they have not set up the panels. They do not have regulations, rules and regulations that can govern even those panels if they exist, and as to how to proceed to deal with the disputes that may arise from them. And many times again, the disputants would come and say, no, I cannot proceed because of the manner of the selection of that panel. The panel does not give me confidence. I believe that there is a lot of influence by the sitting federation members. So they have no confidence in the panels that have been set up. Of course, when you listen to them and you find that, of course, they have a reason to hold such fears, then we have taken the position that we are entitled to then take the matter and proceed with it, and thereafter try to help the federation to set up mechanisms which can assist them in should other disputes arise in future. So the issue of bias, then you deal with it at that point, and you make them, the federations realize that they need to define and refine their regulations and systems so that they do not have their disputes spilling over. The beauty about that is that if matters are heard internally, by the time they come to you, because we have an appellate jurisdiction, then the issues are already defined. The evidence is already at hand, unless a party says maybe they were prevented to bring in some other evidence that was available to them or not available immediately at that time. So you see that now reduces the burden on the part of the tribunal and on the part of the parties, because already the inside panels who are better versed with the specific sport have already sieved the matter on our behalf. The flip side of our jurisdiction, of course, is that, and of course, we've made our process very easy. Simple letter suffices to get before us. But side of it is we've also made it very cheap. So far, we've not even been charging. We've been doing things free, even giving orders and decrees to, and even summons to the parties. Although, as fate would have it, we were this week sitting, that's why I'm in Naivasha, to try and put up those processes, including filing fees and things like that. But we have tried to make it as cheap as possible. Some things are as cheap as $1 to bring an affidavit to the tribunal is as cheap as $1. So we hope that will not limit access, because we have to have we were thinking a balance between access and revenue collection, which of course the government is requiring us to do. The loop side,
I think in NJERI, if I may, that's a very... sorry, I didn't mean to interrupt.
Yes. What's the
No,
question?
please continue. There was a delay, but I had
the
a
loop
little
side.
a signpost there that I'd like to latch onto after you finish your point.
Okay. The limitation that I have found in our 2013 Act is, of course, there's a section that says that sports, you can deal with sports related matters so long as there is agreement between the parties. Of course, do you expect a prospective respondent to say yes when they can say no and drag on the matter or take it to another avenue? For instance, contracts of employment between, say, a coach or a player with the federation or a club even. They will want to latch on to the employment to the employment court, which the respondent will feel much happy with, because it will take forever. It will take another. I think we are on 3 years now before such a dispute is resolved. The claimant would rather run to the tribunal and have that matter resolved, say, in a month, 2 months. But the respondent is not in a hurry. Therefore, they will not give their dispute. And if I was to do an amendment to our Sports Act today, as far as the jurisdiction of the sports dispute, all sports-related matters, be it of contract, be it of whatever nature, first goes to the tribunal. And then we've seen a lot of people going to challenge, running to our constitutional rights courts to challenge the jurisdiction, all manner of constitutional infringements, and all that is delay tactics. I would also make provisions to limit that kind of running to the civil courts.
That kind of activity.
And of course, the courts have been very kind to us. Most of the time, the tribunal is right to have taken jurisdiction on the matter. Let me leave it there for the time being.
No, thank you very much, NJERI. And there's so much there that we can unpick and unpack for several hours, I feel. But unfortunately, we've only got a few minutes left. And one of the points that you did refer to was accessibility and cost, something that we discussed with Dr. RUKARE just a few moments before that. And Jean-Philippe, if you wouldn't mind, I'd invite you to come in here as well, because one of the points of criticism, I think it's fair to say, in relation to the CAS, is that it's referred to as too expensive. Now, ultimately, when we are talking about a dispute resolution mechanism, we are trying to think about it from the perspective of the end user. Accessible is it to the litigant or the appellant at the time? Now, granted, in my humble view, and I think you'll agree with me, I hope you'll agree with me, CAS is less expensive than most international arbitration tribunals. However, it can still be seen as far too dear for many litigants in person. I believe there is some sort of legal aid system there to support certain individuals. Is this something that you can expand on a little bit more so we can spread knowledge of it?
Well, yes. As you mentioned correctly, we are probably not as expensive as many other arbitration institutions. First, because we have to divide the kind of cases we have at CAS in I would say two different kind of cases. But when we have disciplinary cases, so when a federation has a decision that is affecting an individual athlete, for example, and this is a matter of it is an international matter, I'd say. Those kind of cases are free of charge at the CAS. So if it's an international disciplinary matter, there is no cost, no arbitration cost at the CAS. So this is one thing to say. And then when you have other kind of cases, which are what we call the contractual cases, so in matters which involve, for example, a player and a club, or a coach and a club, and so on, and refer to a contractual dispute, then it's true that there are arbitration costs and that the parties have to pay for those costs. But as you mentioned, there are ways of rendering this kind of arbitration cheaper, which first is having recourse to what we have had for quite a few years now, which is legal aid. You can, as an individual athlete, as a physical person, ask for legal aid. So this is something that can help a lot. And also there are other ways to keep the costs down. For example, it is to maybe have recourse to a panel that is a panel of one single arbitrator, what we saw, a sole arbitrator, instead of having a panel of 3 arbitrators. This will also obviously help reducing the costs. What we see also now is having recourse also to virtual hearings rather than physical hearings at the CAS in Lausanne. So, of course, because of the pandemic, we have had an increase in those kind of virtual hearings. But this is also a matter of reducing the costs, because if the parties and the arbitrators are not traveling to CAS in Lausanne, then of course you don't have to pay for all that costs. So holding a virtual hearing is also a very efficient matter to reduce the costs.
Definitely, and there's something I agree with to a great extent. In fact, we've been exposed to several WebEx hearings, particularly during the COVID period. Several WebEx hearings at CAS, and as always, there are benefits and burdens. Whilst it does save on cost and practicality, in my humble view, there is potentially a dilution of the power of advocacy in the hearing. But as with everything, even when we talk about a regional hearing centre, there's going to be a pro and a con there too. But the fact that there are different mechanisms available, which make things more accessible and more cost-effective to the end user, is something that is good, and it's something that I completely agree should be shared widely, so that this general stigma of CAS being too expensive is somewhat more considered than being as curt as that. Now, we've spoken again about some of the positives of CAS and a regional hearing centre. And Donald, as I mentioned before, a regional hearing centre is one that both you and I have strongly advocated for in recent past. But we've also discussed with yourself and NJERI and all the work she's done with the SDT in Kenya, there are a lot of good things going on already. So whilst we don't want to look at CAS Regional Hearing Centre as the sole solution to all issues, what other ways do you think that we could use to make the system better for African sports? Maybe by using certain fora in them with Lisa. What might your thoughts be on something like this?
Yeah, Dave, thank you. I think there are a number of pathways that we can adopt as, let's say, the sports law practice in Africa. And one of them, the kind of theory we had here in Uganda, and it's shared by our colleagues in Kenya, in NJERI, and others, is one, I think the beginning point is that we need to twin this whole idea, even if it's having a regional center for CAS. One of the areas was the kind of, let me say, the knowledge deficit. There was a knowledge deficit in Africa in terms of, as I said earlier, recognizing sports law as a distinct area of practice. So what we endeavored to do was to have a series of trainings or workshops on sports law for Africa. So in Uganda, we took the lead with support from the Olympic Solidarity Sport, and this was on the back of having attended the ISD program in Cambridge, and I realized that there were very few people from the continent of Africa in that course. At that time, I was actually the only one. Yet you find people from Latin America, people from Europe were kind of ahead of the curve. So having attended that course in Cambridge for 1 week, I came back and thought that maybe it's easier, instead of taking a couple of lawyers from Africa to Cambridge or to ISD or to wherever, it's easier to bring that system here. So we started running these programs here in Uganda, doing sports law programs for Africa. And the idea being, one, we build the knowledge base of the sports lawyer, and I'm happy to report now we have close to probably over 80 people who have an appreciation of sports law. And then we also build a community of practice of people who you can begin to have these engagements, even things like having pro bono lawyers who can because one of the issues even is access to legal counsel, and for some of the, whether it's the athletes, that there's a big issue of cost. So one was these programs, and then two, wanted to build this community of practice, like a network of sports lawyers in Africa. And then three was then, what extent now can this group of energized young people who have the knowledge and the passion for advancing sports law, then begin getting into drilling down at national level to the constitutions of the various federations, clubs provide for sports dispute resolution mechanisms, even if they're voluntary, being acceded to, writing in arbitration clauses, being part of these different adjudication panels. So I'm even happy to report that recently one of the big federations here, about 4 of the people who are now on those different adjudication committees or panels are the people we trained in our sports law program. And we have also convinced the Uganda Law Society to come up with a sports law cluster. And Dave, you're an honorary member of that. We have a WhatsApp group. We're discussing all kinds of emerging issues and the permutations. So to me, it's building a knowledge base, creating this group of people, working on the systems, and then hopefully down the line, we might see whether it's a regional hearing center for CAS or having our own system, but which is linked to the CAS system, where, as I agree with Jean-Pierre, that Philippe, the question around having well-agreed rules, well-agreed procedures, mindful of the cost, but I think with issues of technology now, we have been doing a number of result panel management sessions in the anti-doping space, and we do them for free. We're not paid. We go online, we adjudicate the cases, and I think we can find creative ways of going around this issue of cost if we find congruent solutions, but linked to the CAS system. So that's what we're looking at, Dave, and I think there are various ways we can try to advance the sports law agenda and the use of sports dispute resolution mechanisms in different forums. And also, one other area is we have been reaching out to the judiciary by inviting them into our meetings, because a lot of the judicial officers who handle the sports disputes may not understand the kind of nuances of sports law. So we have found that by engaging with the judges, with the magistrates through seminars, through dialogues, roundtable discussions, we're beginning to see a number of judges, what we're seeing in Kenya, a number of judges, when you go to the main courts, they'll say, no, but have you exhausted all local remedies by first going to the arbitration clause that you might have in your sports federation constitution or statutes? So it's those kind of strategies that we want to do. And then lastly, building partnerships across the globe. And I think that's just another area we'd like to see. How can we learn from others who are already ahead of the curve in order to be able to deepen this kind of thing? But at the end of the day, the community of practice of sports law is something which we're very big on.
Excellent. Well, thank you very much for that, Donald. And I'm very conscious now that we're running out of time, so I'd like to very kindly leave the final comment with NJERI. And NJERI, if I may, I'll ask you a leading question. Bearing in mind we've discussed the pros and in some instances the challenges with regards to a regional hearing centre. Jean-Philippe has very kindly given us a great insight onto how that would manifest itself. Donald has also highlighted a number of different ways in which there could be a collaborative approach. Where a country in Africa does adopt a system like the SDT, in your view, would you fall in line with there still being an appeal route from that sports dispute tribunal to CAS, or would you want that to be the final point of call, if I may humbly ask you?
Thank you. Let me pick up from where Don has left in order to answer you. We already have a setup under the WADA program where we have been divided into zones as such. And Don, you and I are of course in charge of our good zone 5. I do appreciate that even we at the tribunal could go wrong. And I do appreciate that a party should be given as much leeway as possible to litigate their matter even to the next level. But I do also appreciate the need to contain the expenses and sometimes even the need to expedite the decision making. I would borrow from both our current SDT setup and for instance, under our anti-doping rules, our tribunal has been given, in matters affecting national athletes, the tribunal has been given jurisdiction both on the first instance and on an appellate instance. And the appellate decision, as far as the national athlete is concerned, becomes then a final decision. I would borrow the same and extend it to the international athletes. Give the tribunal or the tribunal of whichever country is setting up a similar tribunal, give them the first hearing instance, and in some instances also give them the appellate decision making powers, depending on the composition. Like we were 8 or 9, and therefore it is possible to empanel a different panel, and with sufficient number of lawyers, I think at first we were 5.
Sure.
It was possible to set different panels to sit at the first instance and on an appeal. And then for purposes of containing costs, I think I would prefer first that we look at our zonal appellate mechanism. And then for the very super international athlete, give them then the leeway to go all the way to CAS, but do some small, if I would call it that, small CAS within the zone. And even when we've been doing our zone, the appeals have been going. We have had the other regional appeal body where we involve people as far as South Africa. And that has contained costs and still created the ability for the litigants to exhaustively litigate their matter to their satisfaction and contain costs. I would rather go stage wise and give them first and second bite, then a regional bite before they can go all the way to CAS.
Excellent. Well, thank you very much for your views, NJERI, on that. Unfortunately, we have to wrap up because time is pressing. But again, thank you very much to the esteemed panel for appearing today. Jean-Philippe DUBEY, thank you very much for your time. And no doubt we'll be in touch again soon. Dr. Donald Rukhari, thank you very much for appearing from Kampala, Uganda, and of course, Madame NJERI Onyango, who is facing internet challenges but has overcome all of that to stay with us today. Thank you very much for your appearance. And finally, if I may, thank you very much to our good friend Jedida Wafula for your very helpful signage at the bottom of the screen today. Ladies and gents, it's been a pleasure to moderate this panel. My name is DEV KUMAR Palmer, and please stay tuned. We now have No Time for Angels, a wonderful movie from Iran, which is going to be shown. So please stay online. Thank you very much, and hope to see you all soon.
Thank you, Dave.
Thank you all. And
Thank you, Jean.
nice to see you.
Have a great
So wonderful panel, Dave. We've never met, but I'm looking forward to meeting you in the near future. This is the Kenya International Sports Film Festival, and that was a panel on basically the growing popularity of sports arbitration in Africa. There's a saying that the arc of the moral universe is long, but it bends towards justice. And in case you're wondering about arbitration, mediation, legal aid, that kind of thing, we actually do have here in the Republic of Kenya an organization called Kituo cha Sheria, and they provide free legal aid advice. If you'd like more details about that, kindly get in touch with us here at the Kenya International Sports Film Festival. We don't only strive to inform you or entertain you, but also primarily to educate you on all things sports and film. Speaking of film, coming up next, from the Islamic Republic of Iran, a gentleman by the name of Sam Kalantari directed a movie called No Place for Angels. And I guarantee you, wherever you are, at home, in the office, in any social setting, wherever you may be, remember, social distancing maintained, I can almost guarantee you there'll not be a dry eye in the house.